We've heard from some incredible experts today. And of course, we know through our work that technology has become a central part of many significant cases. Because of the profound impact on case outcomes, it is important to understand new developments in the science that produce the evidence and the legal challenges that are being made in your jurisdiction and elsewhere. So let's talk about tech in trial. One of the first things that I would like to discuss is early intervention. If you are able to be involved in the beginning of an investigation, especially in a significant case, take time to talk to your tech experts. Sometimes it's going to be a crime analyst. Sometimes it's going to be a police officer with special expertise. It may even be another prosecutor in your office. Know who that person is in advance and make sure you're taking the time to go and talk to them about what's possible, because it's changing on a daily basis. The second thing, which I just can't impress enough, is send preservation letters. As soon as you have an idea and you've got sufficient data in order to know what you want and from whom, send those preservation letters so that at a minimum, you have the opportunity to secure the evidence if in fact something is deleted or is a part of a system which automatically gets rid of information as part of its business practice. Obtain proper warrants. And that may sound simple, but I think anybody who's done geofencing warrants or a cell tower dump, you know that sometimes it's not quite that simple. It requires that you understand the law in your jurisdiction. There may be some privacy considerations that require special handling. It might include the appointment of a special master at some point or a multi-part search warrant. If that's the case, take the time to educate the court. Whoever you're seeking that warrant from, in your affidavit, provide detailed information about why you want it, why it's important, how you can get it legally and ethically, and be strategic. There are always going to be times where the need for information is absolutely urgent and critical, but there are other times when being patient and perhaps taking warrants in stages can be far more legally sound and more effective in terms of the confidence of the court that what is being done is appropriate. Once you receive data, carefully review it, but do so understanding that as human beings, we have a tendency to want to see what we're looking for. And that's called confirmation bias. And the example that Peter used in one of the cases that we worked together, when I originally saw that there were outlying cell towers, immediately I thought, well, San Diego's got a lot of hills. So it's just a cell tower that's up on a hill and has a bigger reach. Had I not thought any further than that, I may have just chosen to ask Peter on the stand in front of the jury, well, isn't it true that if a cell tower is up on a hill, it may have a farther range? And while that answer is true, that's not actually what the evidence was in that particular case. You've got to scrutinize results. And if you see outlying information, data, anomalies, say something. Because chances are you've got an expert who can tell you why that is going on, or an expert who goes out and does an extra job of hiking through the hills of your jurisdiction in order to show that there's actually not a cell tower at all and the records are flawed. Ask questions. It is very important that you understand the technology. Of course, you're not going to understand it to the same degree as your expert, but you need to be able to explain it to a jury in closing argument. You need to be able to ask effective questions, and that means you need a pretty decent understanding of the basics. Acknowledge problems and try to solve them. It's always better to own it up front, and we'll talk about that a little bit more in the next slide. But if you're seeing something that doesn't look right, hopefully now you have a little bit more information. I think before we might have tended to rely a bit on some of those business records that might be out of date, that nobody may have an interest in keeping them up, or simply may have been mistyped because of how the permitting process was done. Be aware that that actually exists. And if it's a really important case and a really important data point, spend the extra time to have an investigator or an analyst go out to the site and confirm that what you're looking at is in fact there. And don't box experts in. This is a tendency I certainly have had throughout my career. And it's actually Peter who made me realize the importance of this. It's okay to be conservative. If this is the only evidence you have, then you need to really scrutinize your case because the evidence is not quite as specific as we've always thought it was. When we box experts in, sometimes we can pressure them to overreach. And of course, that's going to create significant problems for us down the road when these cases are being litigated in the post-conviction world. Keep up to date on scientific and legal research in whatever area it is that you're looking at. Make sure that you understand what the current legal challenges are so that you can address them, because they're always going to be ongoing. When we're going into trial, prepare your expert. You've got to sit down and talk with folks. Even though they are experts and they're used to testifying, you've got a unique case that's sitting in front of them. You need to make sure that whatever examples you're going to be asking about, hypotheticals, are ones that the expert is comfortable with. And if the expert uses hypotheticals, which you think may be overly technical, this is a perfect opportunity for the two of you to sit together and think about how you might simplify those complex issues in your case in order to have a jury understand this information. Lean heavy on your eliminates. In the situation that we had with the cell towers that were incorrect, there was an eliminate. It was written by us. We wanted to make sure that defense counsel, that the court understood that there was this flaw in the subpoenaed records, because when they come in from the custodian, there's either a person testifying that they're accurate, or there's a piece of paper that swears out that they're accurate. If they're not accurate, we need to own that. We need to own it early. We need to explain what's going on. And you would already, of course, have done that in discovery, but get out in front of it, in front of the court. That also gives you a chance to explain the science in writing. It also gives you a chance to explain why the records might be incorrect that are coming in to support the data that you're trying to admit. Brief the law. Tell the court what's been happening in your jurisdiction. And if nothing's happening in your jurisdiction, look outside of your jurisdiction. Of course, be careful. If you're analyzing new technological data and they're doing Fry hearings or Daubert hearings, you need to understand which standard is being used in the jurisdiction that you're looking at. But even if it's not the same standard, you're going to be seeing what the issues are that are being raised in the challenge and be better able to address them with your experts. So vet your issues and also vet your exhibits. Bring them in, because when this critical information is about to be presented, that's not the time when you want to draw a defense objection and end up in a lengthy hearing that creates delay. Once you're in trial, as I mentioned before, own it, put it out there, explain it, and overcome it. We started out with a problem where we had cell tower sites that were cited in records that didn't actually exist. What happened next was a court order. It had us go out and look at these cell tower sites and take pictures when we did it. Very important to have that documentation. When we ultimately had the testimony about these records, it looked so thorough. It looked so cautious. We were able to overcome it. It actually became a strength in our case. So enjoy the possibilities of this amazing evidence. And for those of you who have perhaps not quite as many resources as some of the other jurisdictions, I want you to know that there are some things that are available to you that you should be thinking about. There was a presentation given by PCE earlier in the year on the Prosecutors Crime Analyst. That session is recorded. Within that session, we heard from Jerry Young, and he runs one of the intelligence centers that is funded by the federal government here on the West Coast. But he presented about a whole group of intelligence centers that can be accessed by prosecutors don't be concerned that these are federal entities. Reach out. They are very willing to help. While HIDA may be having a drug focus, anything that has a drug nexus, including violent crime, they're going to help you with. When you look at the risk centers, they're all over the country and they're divided by region. They have analysts that are there and willing to help. If you take a look at the booklet that is attached to that training, you will see that there are links for all of these resources. And I also want to point you to a publication that PCE has put out called the Prosecutors Crime Analyst. All of these resources can be found at PCEinc.org. And I apologize for not being able to be there in person, but if you have any questions, please feel free to email me at sroach@pceinc.org. Thank you all so much.